In Chapter 12, we begin our study of legal research. This is just an overview. In the Cerritos College Paralegal Program, we offer two legal research classes, beginning legal research and advanced legal research. Each one of those classes is a full semester. Again, this is just to kind of give you a taste of what's involved in conducting legal research. We're going to be covering chapters 12 and 13. In chapter 12, we deal with how to find enacted law, meaning laws that have been codified in codes or in constitutions. In chapter 13, we will deal with court-made law, that is, judge-made common law. The first step in conducting legal research is usually by checking statutes. I remember my first legal research class in law school, the first line of our legal research textbook was check the statutes first. This is true for many reasons, including the fact that statutes supersede the common law. In other words, legislatures can react to court decisions that the legislatures don't like by passing statutes that in effect overrule court decisions. In conducting legal research, we're always working to fit the law to the facts that are presented. And when we're dealing with statutory research, we again have to have our facts before us, locate statutes that might apply to those facts, apply the statutes to those facts, and then come to a conclusion. So how do we find relevant statutes? The easiest way to find statutes is to have a citation to those statutes. There's a good discussion of citations in the textbook, and this just summarizes some of the important matters. One way to locate statutes is by their popular name. As set forth in the slide, things like the Administrative Procedure Act, Clean Water Act, things of that nature. More commonly, statutes are located by their citation. And an example of a citation is in the slide. The citation is an abbreviation for Title V, United States Code, Section 552B3, followed by 2006, the year that the statute was enacted. Statutes are published in both official and unofficial versions. The unofficial versions are typically published by companies like West Publishing and LexisNexis. So to illustrate the difference, the United States Code is an official version published by the United States government. United States Code Annotated is the version published by West Publishing. The unofficial versions are almost always annotated and are much, much more useful to somebody conducting legal research. Annotations will contain references to prior versions of the statute, legislative history behind the statute, and most importantly, cases that have construed the statutes. So we almost always begin our research into statutory law by looking at the unofficial statutes of, or the unofficial codifications of the statutes. In California, we have the California codes that are published by the United States government. But again, most people, or by the California government, I'm sorry, but most practitioners would start with the California annotated codes published by West Publishing. The slide in front of you shows common abbreviations for some federal and state statutes. And again, as I stated, the typical citation includes an abbreviation of the actual statute's name. So again, USC standing for United States Code, USC-A, United States Code Annotated, California Business and Profession Code, again, is abbreviated as noted in the slide. In conducting legal research, the textbook has a really good discussion of how to approach statutes, and I'm not going to go over it in any detail. This is a chapter, however, that deserves more than one reading in order to understand it. So I urge you to read it and then read it again to make sure that you understand the materials. The chapter includes a discussion on how to read and interpret statutes, including such common sense maxims. Be sure to read the entire statute. Look at some particular words in the statutes. Are there words like shall, which is a mandatory word, or may, a discretionary word, included? The inclusion of these different words will affect your analysis of the case. When a statute includes elements, for instance, of a crime or a tort, do the elements include words like and, meaning that they must include all of them, or do they use the term or, which may include? In the statute, look and see if there are definitions in the statutes. Some words and phrases may be defined in the statute, and the definition of the word in the phrase may be different than commonly used. Finally, look for court decisions that construe or apply the statute. This is where you're going to find the most information about your case, and these court decisions will have applied that statute to the facts of a particular case. And finally, is there any legislative history that applies to the statute? The chapter concludes with an extensive discussion of how to prepare a written analysis of a case using the IRAC method. When you take legal research classes, you'll work with the IRAC method and actually apply it. For purposes of our class, I want you to be aware of its existence and generally what it provides. When conducting a legal research, we always want to conclude with a written analysis. The written analysis helps the person focus their research, and it also preserves the research for future reference. The IRAC method is a method commonly used by lawyers, judges, and law students. The IRAC method includes references to the issue presented, I for the IRAC, what the law is, the rule, the R in the IRAC, how the law will affect your client's case, the analysis, A in the IRAC, and finally, what's your conclusion and answer like a result, the C in IRAC. The text concludes with examples of how to use the IRAC method with two of the case studies that are outlined in the book. Case number 14, which appears at page 322, did Mary Smith commit the crime of carrying a dangerous weapon? And case number 15, which appears at page 341, did Mark Brown commit battery when he threw a heavy law book at an intruder in his home, breaking the intruder's spine? Again, the textbook uses the IRAC method to analyze these cases, and I urge you to pay careful attention to see how the IRAC method is used. Again, review the examples carefully. They include good examples of how to properly review and analyze legal problems.